Hello, good day. And this is to continue our discussion with the powers of the corporation. This video discussion is for my students at SPAC for the subject Partnership and Corporation. So we are going to continue with the powers of the corporation. One of the powers is acquisition of own shares. So in this, the corporation will acquire its own shares. And there are reasons behind why a corporation may reacquire shares. So reasons why a corporation reacquire shares. And first reason is in order for for us to nakalagay, for the corporation to remove delinquent subscription. So, what are the rights of delinquent shares? Kasi ito yung mga delinquent shares, medyo siguro explain natin. So, delinquent shares, they have the right to vote is removed, but there is still right to the dividends. So, if the dividend is cash dividend, it will be deducted to the unpaid subscription. So if it is a stock dividend, it will be withheld until you effect payment of your subscription. So, halimbawa ito, delinquent shares. For example, X subscribed to 100,000 in amount for 1,000 shares of, lagyan natin dito, of ABC Corporation, lagyan natin, of, Chorva Corporation. Kahit ano na lang. Corporation. And then, ang binayaran niya, X paid 60,000. So, therefore, he has a 40,000 unpaid. Okay? In his subscription. So, delinquent siya. Hindi siya nakabayad on time on the required date to pay. And then, ngayon, magkakaroon ng bidding. So, para dun sa remaining na unpaid na shares. And by the way, class, yan, dito sa bidding na to, may mga expenses and other interest that another interest incurred na-incur. Yan. So magkakaroon ng bidding. So titignan kung sino yung tinatawag na highest bidder. So the highest bidder, siya yung willing to pay the required amount to be paid at the least number of shares. So, siya yung may pinakaunting share. So, maliban pa dito sa, halimbawa yan, dito, in our example, A, B, and C, they are willing to pay 45,000. Diba sa share, sa ano na to, yung 4,000. And then, plus yung other expenses ito, plus other expenses, which is yung 30,000 sa example natin. Ngayon, tingnan natin. So, A would like to receive 500 shares. So, B would like to receive 490 shares and C would like to receive 480 shares. So, sabi nga natin, ang tinatawag na highest bidder is the person who is willing to receive the least number of shares. So, may pinakaunti. So, in our illustration, C is the highest bidder. Tingnan natin. Highest bidder. Okay? And now, so the corporation will issue the 480 shares to C and the 520 shares to the delinquent subscriber X. Okay? So yun yung one of the reasons why corporation reacquire shares. Yan. Kasi may delinquent nga. So, hindi pa pala ito. Ang reacquisition niya to is if there are, sorry, erase that. If there are no bidders, yan, dito kasi may bidders, ABC. If there are no bidders, the corporation will be a bidder if it has sufficient retained earnings. So by then, the corporation pays 45,000 and the corporation acquires the 1,000 shares na buo. The corporation can opt to retire the shares or to put it to treasury. So, nire-acquire niya itong shares na ito. Kasi class, ito, yung payment niya dito na, dito, di ba, 1,000 shares. Yung payment niya dito na 60,000, i-apply yan sa buong 1,000 shares. In such in such that it means na parang hindi buo yung bayad. So, kasi 'di ba 60,000, 100,000 dapat 'yan. Eh ngayon 60,000 lang yung 60,000 lang yung binayad niya. So, per share, yan, ang percentage na lang parang ang binayaran mo lang is 60 cents per share. So, hindi mo buo na nakuha yung shares na ito. Hindi siya pwede yung payment niya, ia-apply yan sa buong 1,000. So maglalabas is magiging per share is parang 0.60. Yan, per share yung ano, which is hindi bayad ng buo. So kaya yan, pag ni-reacquire ng corporation, yan, yung buong 1,000 shares. Okay? So that is one of the reasons why a corporation reacquire shares in order for the corporation to remove delinquent subscription. Okay? So, number 2, may reason pa yan. Ayan. By the way, ano yan? Reasons why a corporation reacquire shares. Yan. One of the reasons is to remove fractional shares. So, when does a fractional share happen? Diba? Fractional shares is caused by the declaration of stock dividends. So, like for this, in our example, diba, si X has 99 shares when the company declared stock dividend of 20%. So, isipin nyo, so 99 shares times 20, ang dadagdag sa kanya is 19.8 shares. Diba? Parang ang weird, 'di ba, na may may fractional siya diyan na 0.8. So, ang gagawin ng corporation in order to remove this, yan, pwede kasi niya yan, i-reacquire yung parang fractional part ng shares na ito. So, yung 0.8, i-reacquire yan ng corporation. Yan, to remove the fractional shares. Okay? So, number 3, third reason is that payment to dissenting stockholders. Okay. So, ano ba yung dissenting stockholders? So, wait lang natin. When trying to pay dissenting stockholders, so, for example, when a corporation has to make a decision involving amendment of articles of incorporation, giving better advantage to the new issuance of shares, sale of all or substantially all of the corporation's properties, yan, merger or consolidation. Yan. Ito kasi, itong tatlong ito, nandun yan dun sa section 6 na ng code, yung I am sad. Ito yan sila, part ito. So ito, ang required vote niyan requires a majority vote of the board of directors and 2/3 votes of stockholders. So ngayon, di ba 2/3 nga, 2/3 votes of stockholders. So ibig sabihin, yan, kung halimbawa may dissenting stockholder which is siya yung hindi nag-agree, okay? Siya yung hindi nag-agree dito sa mga decisions na ito ng involving the corporation. Say mo 2/3 yung required, so may 1/3 yan. For example, 1/3 na hindi nag-agree. No? Pero yun, yung dissenting stockholders, yan. So, anong nila, remedy nila? Dissenting stockholders. So, they have the right to, for appraisal right. Meron silang yung tinatawag na appraisal right. So, what is this appraisal right? So, appraisal right, this is the right to demand payment of the fair value of your shares. So, ikaw yung stockholder, so, parang ibabalik sa'yo yung the right to demand from the corporation na ibalik sa'yo yung value ng shares mo. O kumpara, bigyan ka ng pera. So, ng pera, parang kinukuha mo pabalik yung shares mo, yung fair value. So, for example, yan, a dissenting stockholder would agree to sell his shares to the corporation for 1 million. Kasi nga hindi siya nag-agree dun sa decision ng corporation. So, gusto niya i-exercise yung appraisal right niya. Yan. So, he then will surrender his certificate of stock to the corporation. Yan. If the stockholder rejects, kasi wala. Yan. Pero halimbawa, yung stockholder nag-reject siya kasi itong si corporation, siya ang mag-o-offer nitong 1 million eh. Siya ang mag-o-offer niyan. So, what if ni-reject ni stockholder yung offer ni corporation? So, Ang mangyayari, magkakaroon ng tinatawag natin appraisal committee will now be created, and it comprises 3 members. So, one of the members, 3 members yung appraisal committee, one of the members, si corporation ang pipili. Another, one will be chosen by the dissenting stockholder. And then the third member is a third party, so outside siya sa kanila, chosen by the representatives of the corporation and the dissenting stockholder. Okay? So the appraisal committee, yun, yung appraisal committee, siya ang magde-determine ng fair market value ng shares na yun. Yung shares mo kung dissenting stockholder ka. Kasi aalis ka na sa corporation, yung essence dyan eh. Kasi you do not agree, no? Dun sa parang mga decisions ng corporation. So, yan. To continue, appraisal committee, they will conduct a meeting to discuss the fair market value of the shares. So, dahil magmi-meeting sila, maaari sila mag-incur ng mga expenses, 'di ba, sa mga meeting nila. So, who will shoulder the expenses they will incur in the meeting? So, it depends. So, kung kanino yung decision na magpa-prevail, yun yung tatandaan nyo. Like for example, dito sa example natin, 'di ba, 1 million. Halimbawa, ni-reject ngayon ni A. Ni A yung 1 million, sabi niya masyadong mababa yung offer na fair market value ng shares ko. Gusto ko mas mataas. Kaya ngayon nagkaroon ng deadlock or hindi sila nag-agree, 'di ba? So ngayon, titingnan natin what if ang decision ng appraisal committee, yan, if in our example the appraisal committee decided that the fair market value is 1 million, ibig sabihin pumanig sila sa corporation, 'di ba? Na 1 million. So then the dissenting stockholder will shoulder the expenses. So in such case, yung dissenting stockholders yung gagastos, okay, nung expenses nung sa mga meeting nila. But if the amount of the fair market value is more than 1 million, the corporation will shoulder the expenses. In this case, dito sa second scenario, yung more than 1 million, pinapanigan nila dito yung stockholder, yung dissenting stockholder. Kaya, therefore, the corporation will shoulder the expenses dun sa meeting. Okay? Yung sa appraisal committee. Okay? So, right now, there is also a right called a preemptive right ng mga, preemptive right ng mga stockholders. So, what is this preemptive right? So, preemptive right is the right to subscribe to issuance of previously unissued shares before it is offered to the public. So, to illustrate yan, may example tayo dito. Diba? Assuming that there are 1,000 issued and outstanding shares of ABC Corporation. And X owns 10 shares. So, gagawin natin 100 pala to. 100 shares. Okay? If the X owns 100 shares, therefore, 'di ba, ang interest ni X, since 100, yung shares niya out of 1,000 na issue, meron siyang 10% na interest. Has 10% interest in the corporation. 'Di ba? Ngayon, what if the corporation issues another 1,000 shares? So, 1,000 yung nauna, nadagdagan, dinagdagan niya ng 1,000. Therefore, the total outstanding will now be 2,000. 1,000 shares, diba? So, ngayon, kung i-compare mo, i-compare mo ngayon yung interest ni ni X, sorry. Diba, 100 shares yung sa kanya and then ngayon naging 2,000 na yung total outstanding. So, bumaba ngayon yung percentage niya sa corporation. Kasi magiging 5% na lang yan. Dati 10%. Bumaba, naging 5%. So, to prevent this, yan, the existing stockholders have preemptive right. So, babalikan natin yung definition ng preemptive right, yan. The right to subscribe to issuance of previously unissued shares before it is offered to the public. So, itong 1,000 shares na additional na to, so, meron silang right, sila yung mga stockholders, mga existing stockholders, has the right, preemptive right, na sila muna ang mag-subscribe ng shares na ito. Sila muna ang bibili ng shares na ito bago ito i-offer sa any other person. Kasi nga, maapektuhan yung interest nila sa corporation. Dito sa illustration natin, bababa yung interest niya. So, ngayon, may option sila, yan. preemptive right na sila muna yung mauna. Okay? Sa rights ng, sa issuance ng shares. So, yun lang siya, class. So, ngayon, there is exception to the preemptive right. Yan. If there is a law, no, in compliance with law requiring the public offering of the shares. So, in such a way na kailangan i-public offer mo siya, hindi magte-take effect yung preemptive right kasi dapat na i-offer mo na siya kaagad sa public. So, I think dito yung mga GOCCs ito madalas mga government-owned and controlled corporation. So, may proprietary function sila. Ayun, yung mga shares na to is kailangan i-offer nila muna sa public na without the right of preemptive right kasi yan, exception siya. So, dito lang muna itong video na to. I will continue the discussion. Wait lang. Stop share. Share tayo ng isa pa. Yung wait. Sana ba yun? Powers of the corporation. The threefold doctrine. Dito tayo. Threefold duties of the directors. So, let's go here. So, as part of our discussion, diba? Threefold duties of directors and other underlying doctrines. With regards, syempre, sa corporation law. So, threefold duties of directors. So, meron silang yung main na duty, yung mga director. So, first is the duty of obedience to the bylaws of the corporation. So, the bylaws are the constitution of the corporation. Dito naka-embody lahat ng mga rules ng corporation, yung laws in them. So, familiar naman siguro kayo sa term na bylaws, no? Sa may mga organizations diyan, may bylaws tayo na sinusunod. So, yan. So, obedience to the bylaws of the corporation, yung first duty ng directors. The next duty is duty of loyalty to the corporation. So, I think may explanation tayo dyan mamaya. And then, number 3 is duty of diligence. So, directors are required to observe the diligence of a good father of a family. So, this is the ordinary form of diligence. So, and punta muna tayo dito sa underlying doctrines. So, there are 5 underlying doctrines, no? We have to familiarize ourselves. You have to familiarize yourself with this doctrine. So, first is doctrine of piercing the corporate veil. I think I have explained this before when we started discussing corporation law. And then number 2 is doctrine of special circumstances. Number 3, doctrine of business or corporate opportunity. Number 4 is trust fund doctrine. Number 5 is doctrine of limited capacity. Okay. So, let's go first. Balikan natin. Doctrine of piercing the corporate veil. So, I think before on our discussion, I think nag-illustrate ako sa inyo, may tela pa nga yan no? Parang tela separating the owners of the corporation from the corporation itself. Kasi 'di ba, sabi nga natin ang corporation has a separate and distinct juridical personality, separates from its owners. So ngayon, may veil yan, may parang tela. Ang magandang tela. Veil. Yan, tela to, 'di ba, veil. So, halimbawa ito yung corporation and ito yung owners or mga stockholders, yan. So, may separate na veil, 'di ba? Na may veil na nagse-separate sa dalawa kasi nga may personality sila na different. Ngayon, when to pierce the veil, kailangan natin punitin itong veil, no? In such a way na pag tinanggal natin siya, yan, when the corporation is being used to commit fraud or to legitimate issue or to avoid taxes, or it is a mere conduct or business or alter ego. Kumbaga, ginagamit yung corporation, um, yan, halimbawa, I think na-illustrate ko na ito before sa inyo. Pag ginamit yung corporation in a form na parang alter ego lang siya, or to avoid taxes, yan, certain commit fraud. So, ipipierce mo siya. So, ibig sabihin, halimbawa kung ikaw yung may claim against the corporation, pwede ka na, pag pinierce mo yan, so wala nang nagse-separate sa owner, sa corporation at sa kanyang owner. So, pwede ka nang pumunta sa owners ng corporation. Doon ka magki-claim sa kanila. Kasi class, remember, 'di ba sa corporation, you can only claim, 'di ba, from the extent na capital contribution ng mga shareholders, 'di ba? Hindi mo sila pwedeng habulin yung personal sa personal assets nila. Pero ito, pag pinierce mo yung corporate veil, pwede mo na silang habulin. When it comes to their personal properties, kasi nga they use that to commit fraud, yan, confuse legitimate issues, yan, or alter ego. So yun. So yun yung doctrine of piercing the corporate veil. I've discussed that before. We just try to review it now. And then ito, doctrine of special circumstances. So ito, duty to disclose to the shareholders what is happening in the in the corporation. If there is concealment, there is fraud. That's why class, may mga meeting ang mga stockholders yan every 15 ata ng April. Yan. So and kailangan ma-inform mo din sila yung financial status ng corporation, 'di ba? Ano na ba yung nangyayari, kasi yan, you have the duty to disclose to the stockholders what is happening in the corporation. That is doctrine of special circumstances. Okay? So, what about doctrine of business or corporate opportunity? Okay. Related ito class sa duty of loyalty. 'Di ba kanina, number 2 yan dun sa threefold duties ng director. So, okay. Related siya sa duty of loyalty. For example, isa siya ito. This is example natin. For example, Mr. Y offers ABCD Corporation a contract. Okay, si Mr. Y nag-offer sa ABCD Corporation. And he talked to Mr. A, who is a member of the board of directors of ABC. Lagyan natin, of ABCD. And si Mr. A, meron din siyang separate property. Ayan. So, may kaya din ito. So si Mr. A yung kausap niya, 'di ba? Director si Mr. A. So, and this contract, yung pinopropose ni Mr. Y, will give profits to the corporation. And ngayon, this will make A ponder, no? Iisipin ni A, if he gives the offer to the corporation, yan, the latter will profit, 'di ba? Kasi siya yung kausap ni Mr. Y, 'di ba? Tandaan niyo, siya yung kausap. Meron din siyang parang budget, may separate properties din siya, si Mr. A. So sa pag-iisip niya, okay, kapag ibibigay ko to sa corporation tong contract na to, kikita ang corporation. What if pwede naman ako na lang, yun, yung gagawa dito sa contract na to, sabi niya. Kasi may personal assets na siya eh. Ibig sabihin, magpo-profit ako, yun yung iisipin ni Mr. A. Ngayon, if he chose the latter, yung second option, na kinuha niya for himself, yung contract na yon na was intended actually for the corporation, he will violate this doctrine. Yan. Imbis na you are giving an opportunity for the business or the corporate opportunity, you steal it. Diba? So, binayolate mo yan, yung doctrine of business corporate opportunity, and lalo na ito, yung duty of loyalty to the corporation. Diba? Kasi as a director, syempre, kailangan i-prioritize mo muna yung duty mo sa corporation. Ayan, dapat yun muna bago yung sa sarili mo. So, yun yung sa doctrine of business or corporate opportunity. Okay. Now, let's go to trust fund doctrine. Okay. Trust fund doctrine, so, the public in general, the creditors in particular, have the right to expect that the capital stock of a corporation is fully supported by its assets. Therefore, there should be no issuance of shares unless fully paid. Okay? Trust fund doctrine. So, dapat daw lahat nung, 'di ba, pag nag-present kayo ng financial statements, yung capital, share capital nung ano mo, nung corporation, dapat yun, supported yung capital mo by the assets. So, halimbawa, ang nagkakaproblema kasi dito, class, is yung tinatawag na, alam mo yung utang na loob. Minsan nangyayari yun eh, yung sa halimbawa, hindi ko na nilagay kasi dito. Nilagay ko ba? Hindi ko nilagay dito. Halimbawa, yung sa illustration is, nag-subscribe ka sa ABC Corporation ng 100,000 share, 100,000 for 1,000 shares. Ngayon, friend mo yung mga friend mo yung mga officers doon, mga directors doon. And then sabi mo, ay pwede ba na na 60,000 muna yung ibayad ko. Pero ipa-appear mo sa book na nabayad ko na lahat. Pero actually 60,000 lang yung binayad niya. So ngayon, syempre magre-record yan, pa-receive ng corporation yung cash, tapos ordinary share capital. Ngayon na doon kay kasi sabi niya i-issue mo na lang sa akin. 'Di ba? So yung asset, yung buong 100,000, ang nabayaran niya lang talaga 60,000. So yung 40,000 doon is not backed up by an asset, 'di ba? Yung capital na makukuha niya. So watered stocks yun, class, yung ganong scenario. Kasi yun, so hindi na back upan ng assets yung capital. So, delikado yun. Kasi yun pala, ay, wala pala, papel lang pala yung nandun sa, yung nasa record lang. Pero sa totoo lang, wala talagang asset na nagsusupport dyan. So, you will violate then trust fund doctrine. Okay? Kasi, general yan. Have the right to expect that the capital of corporation is fully supported by its assets. No issuance of shares unless it is fully paid. Okay? So now let's go to Doctrine of Limited Capacity. So bear in mind that the corporation has powers, and these powers must be expressed, implied, or incidental. All your activities should be within or inside the powers or intra vires. If the act is outside, it is called ultra vires act. So remember, class, ito, 'di ba yung sa when the state grants a franchise to the corporation niya, tapos may purpose kasi yan eh. Diba, yung business niya is, dito sa natin. Yung business niya is selling of, selling of shoes, yung business niya. Ngayon, if yun lang yung nakalagay, primary purpose. Ngayon, halimbawa, nag-action nag-form siya ng other transact siya ng other things na, diba, ang binenta niya is asukal, diba, layo. Asukal, from shoes, naging asukal na yung binenta niya. So, outside the scope of his authority yun. Ultra vires act. Okay? So, kasi ang authority niya lang talaga is to sell shoes, yun, with this purpose. Ngayon, the power granted to the corporation. So, there are two kinds of ultra vires acts. Okay? So, it can be also legal or meron din yung illegal na tawag. So, if legal, see to it if executed already or executory. Remedy, if executed already, bring to shareholders if they want to ratify. If executory, abandon the act. If illegal, it cannot be ratified. All members of the board of directors will be liable except if the member gave written objection to the corporate secretary. So, tingnan natin siya dito. If ABC Corporation, yan, obtain franchise from the state to distribute and sell cars. So, bentahan ng kotse itong sa kanya. Purpose niya, then the corporation decided to sell TV sets and appliances, di ba? Maglayo, magkaiba. So, this act is ultra vires. But this act is still legal. According to, di ba, wala namang masama talaga sa pagbebenta ng TV sets and appliances. It just so happened na this is outside the scope of its authority. Kasi yung sa franchise niya, selling of cars ang business niya. Yun. But it is still legal. What if the corporation decides to sell shabu? Yan na, iba yan. Ultra Vires Act na yan and illegal pa. Kasi bawal yan sa batas. Okay? Ayun siya, class. So, alam pala yung na-discuss ko sa threefold. So, ito tayo. Share screen pa ako na isa. So, dito tayo, class, sa dito tayo sa corp. Kasi hindi ko na ito nagawa ng PowerPoint. So, daanan natin siya saglit. Itong close corp, sa meetings tayo. Meetings. Okay, meetings tayo. So, there are kinds of meetings na yan. Meeting of the directors, trustees, stockholders, or members yan. Maybe regular or special. So, regular or special ang meeting. So, regular and special meetings of stockholders or members. Yan. Regular meetings of stockholders or members shall be held annually. So, pag regular ng stockholders regular meeting ng stockholders shall be held annually on a date fixed in the bylaws, or if not so fixed in the bylaws, pag di sinabi sa bylaws, on any date after April 15 every year as determined by the board of directors or trustees. So why April 15, class? If you can remember, ang filing ng income tax return is April 15 yan. Yan yung busy day para sa mga accountants. Yung prior niyan, April 15, yung mga, halos walang tulog na yung mga accountants dyan. Kasi filing of ITR, and one of the requirements sa filing of ITR is yung financial statements. Okay? So, audited financial statements yan. Kailangan na audit na financial statements. So, yun. So, after ng April 15, yan, pwede mag-meet na, regular meeting yung stockholders. Kasi yan, pwede na nilang i-discuss yung nangyaring financial statement, yung financial matters nila the prior year. Kasi ganun eh. Kumbaga, limbawa 2020, yung financial statements mo, ang filing ng ITR niyan is 2021. Yeah, on or before April 15. Yung dun sa filing ng ITR mo, income tax return, is kailangan doon, one of the requirements na i-attach mo doon is yung audited financial statements. So, for that year, for halimbawa, yung 2020. So, yan. So, regular meetings of stockholders or members shall be held annually on a date fixed in the bylaws, yan. And if not fixed, any date after April 15 of every year. Okay? Provided further that the written notice of regular meetings may be sent to all members or stockholders of record through electronic mail. So, ito bago to sa revised corporation code yan. Pwede na sa email or such other manner as the commission shall allow under these guidelines. Okay? At each regular meeting of stockholders or members, the board of directors shall endeavor to present. Yan. So, basahin nyo na lang ito, yung sa minutes nila, yung voting tabulation procedures ng mga previous meetings, mga matters discussed, mga resolutions, yung mga opportunity given to stockholders to ask questions. Yan, pwede na dyan. A record of the voting results, a list of directors, yan, such other items that the commission may require in the interest of a good corporate and protection of minority stockholders. Yan. Basahin nyo na lang to. Yan, financial report of the preceding year. Tingnan nyo financial report of the preceding year, di ba? So, yan na yung nagmamatter kasi na mga financial statement. Kaya after April 15, yung meeting nila. Kung marami pa dyan, basahin nyo na lang yan. So, ito. Wow, yan, dami yan. So, a director, trustee, or stockholder member may propose any other manner for inclusion in the agenda at may regular meeting of stockholders or members. So, yun yung sa regular meeting. What about yung special meeting? So, special meetings of stockholders or members shall be held at any time deemed necessary or as provided in the bylaws, provided that at least 1 week, 1 week 1 week written notice shall be sent to all stockholders or members unless a different period is provided in the bylaws. So, pag special meetings of stockholders or members, yan, kung kailan necessary, at any time din necessary, provided na mag-provide ka muna ng written notice, no? At least 1 week shall be sent sa kanila, sa mga stockholders. So, natin yan. A stockholder or member may propose the holding of a meeting and items to be included in the agenda. Notice of any meeting may be waived, expressly or impliedly by any stockholder or member. So, kasi ito, required na, di ba? Required na dapat may written notice dun sa stockholder. So, pwede yung stockholder, i-waive niya yung right niya sa notice. Yan. Pwede yan expressly or impliedly na i-waive niya. So, parang in a sense na hindi mo na siya parang hindi mo na violate yung right niya kasi kung nag-waive siya, give up niya yung right niya na mabigyan ng notice. So, yan. So, provided that the general waiver of notice in the Articles of Incorporation or bylaws shall not be allowed. Provided further that the attendance at a meeting shall constitute a waiver. So, di ba, sabi mo natin, provided that attendance at a meeting shall constitute a waiver of notice of such meeting, except when the person attends a meeting for the express purpose of objecting to the transaction of any business because the meeting is not lawfully called or convened. So, halimbawa, sabi nga natin, di ba, ito, provided na, halimbawa, yung stockholder, yan, na, hindi siya nabigyan ng hindi siya nabigyan ng notice. Pero nandun siya sa meeting. Di ba? So, waiver na yun. Constitute a waiver of notice. Kasi nandun naman siya eh. Except, kung nandoon siya, para i-object yung meeting na yun kasi hindi lawfully called or convened. Kumbaga, okay, pumunta siya dun sa meeting kasi hindi proper, kasi nga wala siyang notice. Yun. Pwede yun, dito. Pero kung halimbawa, pumunta siya doon sa meeting na hindi naman kontrahin yung meeting, it's not lawfully called, pumunta siya doon, kahit na wala siyang notice. So, kumbaga parang waive na, waive na yung right niya sa notice. So, parang good as if parang meron na rin siyang notice. Kasi doon naman siya, 'di ba? 'Yun. Unless nga kinokontra niya yung meeting, okay? So, whenever for any cause there is no sign na natin. Unless the bylaws provide for a longer period, the stock and transfer book or membership shall be closed. So, yung stock and transfer book or yung membership book shall be closed at least 20 days for regular meetings and 7 days for special meetings before the schedule set of the meeting. So, okay. So, unless the bylaws provide for a longer period, yan, kung walang stipulation yung sa bylaws, yan, yung stock and transfer book, nakalagay dyan yung, or membership book, yung mga listahan ng mga stockholders during such time, i-close yan, sasara yan, at least 20 days kung regular meeting and at least 7 days for special meetings. Yan. Before the schedule. In case of postponement of stockholders or members' regular meetings, written notice thereof and the reason therefore shall be sent to all stockholders or members of record at least 2 weeks prior to the date of the meeting unless a different period is required under the bylaws or regulations. So, kapag may postponement daw, yan, you have to notify or send to stockholders or members of record at least 2 weeks prior to the date of the meeting. Okay? So, the right to vote of stockholders or members may be exercised in person. through remote communication or in absentia. So, eto class, bago ito dito sa corporation code, yung remote communication or in absentia. Ano ba yung remote communication na tinatawag? Halimbawa, ang meeting na nila yan, your right to vote, sa mga meeting nila, pwede ng teleconferencing yan. Halimbawa, ito sa atin, Zoom, o kaya Google Meet, pwede na. Ayun. So, not necessarily na yung presence mo na nandun ka talaga sa mismong office. Pero yun, pwede na nga yung video conferencing. Ayun. So, tayo, place and time of meeting of stockholders or members. So, pag ang meeting, pag ang meeting, stockholders or members, stockholders or members, whether regular or special, shall be held, tandaan nyo to, in the principal office of the corporation, as set forth in the articles of incorporation, if not practicable, or if not practicable, in the city or municipality where the principal office of the corporation is located. Okay. Provided that any city or municipalities, pag Metro Manila kasi, Metro Cebu, shall for this purpose be considered a city or municipality. Pag halimbawa sa Metro Manila kasi, iba-ibang city yung meron sa Metro Manila. May Manila, may Makati, may Pasay, may, basta yung Quezon City, kapart din siya. So, i-consider siya na basta along Metro Manila, pwede yung meeting na yon. So, ito, ulitin natin place and time of meeting. Pag stockholders or members, stockholders or members meeting, whether regular or special, shall be held, okay, in the principal office of the corporation. So, halimbawa, ang corporation is located in Davao City, So, pag nag-meeting ang mga stockholders or members, sa principal office nila, nasa Davao City of the corporation as set forth in the, pag hindi naman practicable, pag hindi convenient sa mga stockholders or members, diba? Pwede din na as long as in the city or municipality where the principal office corporation is located. So, diba yung sa Davao, diba? Diba hindi convenient dun sa principal office ng corporation sa Davao kasi malay mo na may under construction na ginagawa dun sa office. So, sabi nila, basta as long as it is within the city or municipality. So, as long as within Davao, doon mag-meet ang mga stockholders or members. Yan. Okay? So, notice of meeting shall be sent through the means of communication provided in the bylaws, which notice shall state the time, place, and purpose of the meetings. Each notice of the meeting shall be accompanied agenda. Pwede rin kasi na may proxy. Pwede may proxy yung mga stockholders ito sa meeting. So, when attendance, participation, voting are allowed by remote communication or in absentia, the requirements and procedures when a stockholder member elects election, when the meeting is for the election of directors, the requirements and procedure for nomination and election. So, basahin nyo na lang itong part na to. So, quorum in meetings. Alam ko na-mention na natin ito before. Paulit-ulit natin. So, a quorum shall consist of the stockholders representing a majority. Majority. Kung sa stockholders, majority of the outstanding capital stock or majority of the members. In case of non-stock. So, Section 52, regular and special meetings of directors or trustees, may quorum din. Unless the articles of incorporation or the bylaws provides for a greater majority, a majority as stated in the shall constitute a quorum. So, general rule kasi kapag walang sinabi yung sa articles of incorporation, para pagkuha ka ng quorum sa directors or trustees on their meeting, so yung majority of the directors or trustees yun. Pero pwede rin kasi na mag-provide ang articles of incorporation ng higher quorum. Yan. Meetings of directors of trustees of corporation. Ito, class, ito. Dito tayo sa regular meetings of the board of directors or trustees of every corporation shall be held monthly. Okay? O kapag regular meetings ng board of directors, kanina, regular meetings ng stockholders yun yung annual, yung April 15. Ito, pag board of directors shall be held monthly unless the bylaws provide otherwise. Okay? Special meetings of the board of directors or trustees may be held at any time upon the call of the president or as provided in the bylaws. Okay? Ito, meetings of directors of of corporation may be held anywhere in or outside the Philippines unless the bylaws provide otherwise. So, notice of regular or special meeting stating the date, time, and place of the meeting must be sent to every director or trustee at least 2 days prior to the scheduled meeting unless a longer time is provided in the bylaws. A waiver or sorry, a director or trustee may waive this requirement either expressly or impliedly. So class, ito, emphasize natin kanina yung diniscuss ko is meeting of stockholders. So, pag meeting of stockholders, balikan natin meeting of stockholders sa principal office of the corporation. Kung hindi practicable, as long as within the city or the municipality. Pero ito, meetings of directors, yan, or trustees of corporations may be held anywhere, okay? Anywhere in or outside the Philippines unless the bylaws provide otherwise. So, kailangan lang bigyan mo sila ng notice, no? Whether it is regular or special meetings, give them a notice stating the date and time of the meeting at least 2 days prior to the scheduled meeting. Okay. I hope malinaw yan, class, yung difference kapag ang meeting ay stockholders, pwede ko ito ilabas sa exam, pag meeting ay stockholders sa principal office, no, ng corporation, kung hindi practicable, as long as nasa city or municipality kung saan located yung principal office. Sa directors naman, meeting of directors or trustees may be held anywhere in or outside the Philippines. So, pwede sila mag-abroad. Meeting nila abroad. Saya. Unless the bylaws provide otherwise. Okay? Ngayon, directors or trustees who cannot physically attend or vote at a board meeting can participate and vote through remote communication. Yun yung sinasabing na remote communication. Pwedeng umattend sila ng meeting through remote communication. Bawa, video conferencing, teleconferencing, or other modes of communication that allow them reasonable opportunities to participate. Okay? To participate. So, pwedeng, like sa atin, di ba, Google Meet yung gamit natin. Video conferencing. So, ayun din, pwede na din. Ito, bago ito sa revised corporation code. Itong, remote communication. Directors or trustees cannot attend or vote by proxy at a board meeting. So, kailangan sila kasi sa stockholder pwede ang proxy. Pero pag directors or trustees cannot attend or vote by proxy at board meeting. So, hindi pwede sa kanila. Cannot attend. Size natin yan. A director or trustee who has a potential interest in any related party transactions must recuse from voting. Basahin nyo na lang yan. So, ito. Who shall preside at meetings? Na-discuss na natin to before. Tinanong ko to sa recitation before. Who shall preside at meetings? The chairman. Or in his absence, the president shall preside at all meetings of the directors or trustees, as well as of the stockholders or members, unless the bylaws provide otherwise. Okay? So, si chairman who shall preside at meetings? The chairman. Okay? So, basahin nyo na lang itong part na yan. Ito. Manner of voting proxies. Stockholders and members may vote in person or proxy in all meetings of stockholders or members. Kasi tandaan nyo yan pag stockholders or members, pwede ang voting via proxy. Kung magsisend ka ng other representative mo, yung hindi ikaw mismo. Yung proxy, alam niyo naman yung siguro yung term na proxy. In all meetings or stockholders or members. Pero kapag director, yan, directors or trustees na vote, hindi pwede ang proxy sa stockholders and members lang. So when authorized by the bylaws or by a majority of board of directors, the stockholders or members may also vote through remote communication or in absentia. O pwede na naman dito sa kanila yung mga teleconferencing like Google Meet or Zoom, ganyan. That the votes are received before the corporation. Sa inyo na lang yan. So, etong sa voting trust agreement class, I leave this to you. Basahin niyo itong voting trust agreement. So, hindi na natin siya masyado i-discuss. O, dito tayo. Pasadahan natin nito. Stocks and stockholders. So, subscription contract. Any contract for the acquisition of an issued stock in an existing corporation or a corporation still to be formed shall be deemed a subscription within the meaning of this title. Okay? Dati kasi class iba ito yung sa old na corporation code. Ngayon, basta as long as nag-issue, ang corporation nag-issue ng shares from its unissued shares, no? Nag-acquire yung another person, automatic subscription na kaagad yun. Okay? Subscription na kaagad siya. O one person, yun, any contract, yung one person, yan, isang stockholder, nag-acquire siya from the unissued stock sa isang corporation or corporation still to be formed, automatic, yung contract na yun is shall be deemed a subscription within the meaning of this title. Not withstanding the fact that the parties refer to it as purchase or some other contract. Yan, subscription pa rin siya, okay? So, basahin nyo na lang itong pre-incorporation subscription. Dito tayo. Consideration for stock. Stock shall not be issued for a consideration less than the par or issued price thereof. Consideration for the issuance of the stock may be actual cash paid to the corporation, property, labor. Yan, marami dito. Ito yung mga pwedeng consideration. Halimbawa, ayan. Mag-i-issue ng yung isang yung isang person gusto maging stockholder, okay? So, ngayon, pumunta siya doon sa corporation, bili siya ng stock, ang papabayad niya, yan. Pwede niyang pambayad para may issuehan siya ng stock is, yun, pwedeng actual cash, yan. Pwedeng property, pwedeng labor, performer services, reduced incurred indebtedness of the corporation, amounts transferred and yan, shares, and other generally accepted form of consideration. Okay. So where the consideration is the other than the cash consists of intangible property, pwede din, subject to the approval of the corporation. So, yan. Certificate of stock and transfer of shares. The capital stock of corporation shall be divided into shares for which certificates shall signed by the president or vice president, countersigned by the secretary or assistant, and sealed shall be issued in accordance with the bylaws. So, yan. I-issuehan ka ng certificate of stock. Yan. Shares of stock so issued are personal property and may be transferred by delivery of the certificate of diba? Endorsed by the owner. Basahin nyo na lang itong part na to, okay? And issuance of stock certificates, interest of unpaid subscription, delinquency sale na na natin to na discuss natin kanina earlier. So ngayon, corporate books and records, merger and consolidation. Merger and consolidation, pasadahan lang natin saglit. Plan of merger or consolidation. Two or more corporations may merge into a single corporation which shall be one of the constituents or may be consolidated into a new single corporation. So, ito kasi class, sa merger or consolidation, ang merger is, halimbawa, dalawang corporation ito. So, halimbawa, corporation A and corporation B. No? Pag sa merger, one of the corporation will remain. Okay? So, halimbawa, A plus C, A, corporation A sa si B, pag mag-merge sila, A plus B, ang mangyayari, either si A or pwedeng si A yung manatili. I-absorb ni A si B. Ganon. So, A, halimbawa, A plus B is equals to magiging A. Ganon. So, ngayon, ito, sa consolidation naman, dalawa sila magko-combine. So, A plus B, pwedeng maging AB. Ganon. Yung sa difference nila. Yung sa And sa merger yan, constituent corporations may consolidate into a new single corporation which shall be the consolidated corporation. So, basahin nyo na lang yung part na yan, merger and consolidation. Dami kasi nito. Appraisal right, tapos na tayo dyan kanina. Non-stock corporation, napasadahan na rin natin yan. So, doon tayo sa closed corporation. Closed corporation. Okay. Closed corporation. So, ito yung mga gusto kong maalala nyo sa closed corporation. So, pag closed corporations, usually ito mga family corporation ito klase. Kumaga, ayaw nilang i-share yung ayaw nilang i-share yung corporation nila sa iba na mga stockholders. So, limited lang. Tingnan natin dito. Closed corporation within the meaning of this code is one whose articles of incorporation provides that all the corporations issued stock of all classes exclusive of treasury shares shall be held of record by not more than a specified number of persons not exceeding 20. So, basahin ko muna to letter B. All the issued stocks of all classes shall be subject to one or more specified restrictions on transfer permitted by this title. And letter C, the corporation shall not list in any stock exchange or make any public offering of its stock of any class. So, ito class, closed corporations, mayroon silang sense of parang exclusive sila. So, dun sa letter A dito, the corporation issued stocks, yung ano nila, yung mga stocks nila, yung mga shares nila, shall be held by not more than not exceeding 20 persons. So, ibig sabihin, 20 persons lang yung pwedeng maging maximum na pwedeng maging stockholder ng corporation na to. Kasi closed corporation nga ito eh. Gusto nila may sense of exclusivity sila. So, not exceeding 20 persons yung mga stockholders ng corporation na to. And another ito, yan. So, in order for you to, ayan, yung letter B, subject to one or more specific restrictions on transfer. So, ikaw na stockholder ka, hindi mo basta-basta maita-transfer yung yung stocks mo to other person kasi may restriction. One or more restriction sa transfer ng shares. Diba? So, the corporation shall not list in any stock exchange. Ito. Hindi sila corporation, hindi nila ipa-public offer yung stocks nila. Hindi nila i-offer sa iba. Kasi nga limited lang sila eh, 'di ba? Isipin nyo, 20 lang yung mga shareholders. So, dapat hindi siya naka-list sa stock exchange. Kasi yung stock exchange yung market ng yung trading, open trading ng share. So, hindi sila dapat naka-list doon. Okay? Hindi rin sila nag-make ng public offering. Notwithstanding the foregoing, a corporation shall not be deemed a closed corporation. And at least 2/3 of its voting stock is owned or controlled by another corporation. So, hindi siya closed corporation kung yung 2/3 or 2/3 of its voting stock ay kinokontrol ng other corporation, which is not a closed corporation within the meaning of this code. So, tandaan nyo class, pag closed corporations, ito, para mabilis tandaan, sa letter A yung 20, okay? Not exceeding 20 persons ang stockholders. Letter B, restriction. Kaya ako, ang ano ko dito is 20 RS ang acronym ko dito. So, restriction. So, subject to one or more restriction. Letter C, sabi dito, shall not enlist in any stock exchange. So, stock exchange, case hindi pwede. Or make any public offering. So, in order for you to remember, 20 RS. 20 is yung not exceeding 20 persons. R is subject to one or more specific restriction. And S is stock exchange. So, hindi siya pwede in-list sa stock exchange. Okay? 20 RS, closed corporation. Okay. Ngayon, may mga specific sa closed corporation. Basahin nyo na lang ito, pero meron akong gustong i-emphasize dito. Pagdating sa closed corporation, so, preemptive right of stockholders in closed corporation shall extend to all stock to be issues, including reissuance of services or in payment of corporate debts. Ito, gusto ko itong i-emphasize ito sa closed corporation. Kasi, kapag ang stockholder ng closed corporation gusto nang umalis, yan, ganyan, any stockholder of, di ba, withdrawal of stockholder or dissolution of corporation. Dito, any stockholder of a closed corporation may, for any reason, any reason, compel the corporation to purchase shares held at fair value. Pwede siyang umalis kahit kailan niya gusto. And pwede niyang i-compel ang corporation na bayaran yung fair value ng shares niya. Which shall not be less than a par or stated value. Provide when the corporation has sufficient assets in its books to cover its debts and liabilities exclusive of capital stock. So, ganito. So, ang isang stockholder ng closed corporation, for any reason, kahit anong rason, pwede siyang umalis sa corporation. At pwede niyang i-compel ang corporation na bayaran siya ng fair value ng shares niya. Okay. As long as pa rin, may condition pa rin. So as long as yung corporation ay may sufficient assets in its books to cover its debts and liabilities exclusive of capital stock. Okay. And provided that any stockholder of a closed corporation may by written petition to the commission compel the dissolution of such corporation whenever any acts of the directors, officers, or those in control, wherever any acts of the directors, officers are illegal, fraudulent or dishonest, oppressive or unfairly prejudicial to the corporation or any stockholder, or whenever corporate assets are being misapplied or wasted. So, pwede siyang magsulat sa commission. Commission dito yung Securities and Exchange Commission. Okay? So, again, pag sa closed corporation, yung stockholders, for any reason, pwede siyang umalis. Okay? Okay, doon na tayo pumunta sa one person. Kasi yung mga importante lang yung discuss ko dito. One person corporation, okay? Applicability of provisions to one person corporation. So, tandaan nyo class, ito bagong-bago talaga to, one person corporation sa panahon na nitong sa revised corporation code. So, ano nga ba itong one person corporation? So, the provisions of this title shall primarily apply to one person's corporation. Other provisions of this code apply supplementary except as other. Supplementary yung other provision. Pero ito sa chapter na to, tungkol sa one-person corporation, okay? So, ano nga bang one-person corporation? Diba? One-person corporation is a corporation with a single stockholder. Isa lang yung stockholder. Provided that only a natural person, trust, or an estate may form a one-person corporation. So, single stockholder siya, and then only natural person, trust, or an estate ang pwedeng mag-form ng OPC. Okay? Banks and quasi-banks, pre-need trust insurance, public and publicly listed companies, and non-chartered government and controlled corporations may not incorporate as one-person corporations, provided that a natural person who is licensed to exercise a profession may not organize as a one-person corporation for the purpose of ito. Yung mga hindi pwedeng mag-organize ng one-person corporation na specify dito. O yan, banks. Yan, yung mga trust, insurance, public and public listed companies. Hindi pwede sila sa OPC. Tapos ngayon, itong natural person din, kung ang gusto niyang i-practice is practice of profession, ay hindi pwede yung OPC, yung one-person corporation. Okay? Except as otherwise provided under special laws. General rule yun na hindi siya pwede yung for the exercise of the profession. Okay? So, minimum capital stock not required for one-person corporation. A one-person corporation shall not be required to have a minimum authorized capital stock except as otherwise provided by special law. Okay? Articles of incorporation. One-person corporation shall file articles of incorporation in accordance with the requirements under Section 14 of this code. And it shall likewise substantially contain the following. So, if the stockholders is a trust or an estate, the name, nationality, yan. Nakalagay naman dyan. Mga requirements, yan, may nationality requirements, and alternate nominee, and the extent coverage yan. So, bylaws, the one-person corporation is not required to submit and file corporate bylaws. Okay yan na. So, let me make that clear. Okay. Pag OPC, one-person corporation, not required to submit and file corporate bylaws. Okay? Baka lumabas yan sa true or false. Careful kayo. Okay. Display of corporate name. A one-person corporation shall indicate the letters OPC either below or at the end of its corporate name. Okay? So, kailangan may OPC. Yan. Sa one-person corporation. So, single stockholder as director president. Kasi isa nga lang siya, di ba? One person nga eh. So, the single stockholder shall be the sole, siya na yung director, and siya na yung president. The one person. Siya na, di ba? Siya na. Siya yung director, siya yung president. Okay? Treasurer, corporate secretary, and other officers. Within 15 days from the issuance of its certificate of incorporation, the one-person corporation shall appoint a treasurer, a corporate secretary, and other officers as it may deem necessary. And notify yan. Kung feeling niya kailangan, yun. And notify the commission thereof within 5 days from the appointment. Okay? The single stockholder may not be appointed as the corporate secretary. So hindi pwede, yung stockholder nyo, hindi pwede na siya na din yung corporate secretary. So, a single stockholder is likewise self-appointed treasurer shall give a bond. Okay. So, pag treasurer, yan, pwede. Okay. Pag secretary class, hindi. Okay. Single stockholder ka, hindi pwede na ikaw yung secretary. So, pero ito, single stockholder ka, pwede kang maging treasurer. Pwede kang maging self-appointed treasurer, pero kailangan shall give a bond to the commission in such a sum as may be required. So may bond ito na, may cash bond ito, provided that the said stockholder treasurer shall undertake in writing to faithfully administer the one-person corporation's funds to be received as treasurer and to disperse and invest the same according to the articles of incorporation as provided by the commission. The bond shall be renewed every 2 years as often as may be required. Kasi may bond nga. Okay. Yan ay kung ikaw na yung single stockholder, ikaw pa yung treasurer. Okay? Special functions of the corporate secretary, basahin niyo na lang ito. So, ito class, importante ito. Yung nominee and alternate nominee, section 124. Okay? Nominee and alternate nominee. The single stockholder shall designate a nominee and an alternate nominee. So, dalawa na, nominee, meron siyang alternate nominee, who shall, in the event of the single stockholder's death or incapacity, take the place of the single stockholder as director and shall manage the corporation's affairs. So, kapag si single stockholder daw namatay or naging disabled, yan, yung inassign niya na nominee, yan, o alternate nominee, yung mag-take place, yung papalit sa kanya, and mag-ooperate ng corporation affairs, yan. The articles of incorporation shall state the names, residence, and contract details of the nominee and alternate nominee, as well as the extent and limitations of their authority. in managing the affairs of the one-person corporation until the stockholder, by self-determination, regains the capacity to such duties. Yan. So, in case of the death or permanent incapacity of the single stockholder, namatay yung stockholder, the nominee shall sit ito as a director and manage the affairs of the one-person corporation until the legal heirs of the single stockholder have been lawfully determined, and the heirs have designated one of them or have agreed that the estate shall be the single stockholder of the one-person corporation. The alternate nominee shall sit as a director and manage a one-person corporation in case of the nominee's inability, incapacity, or refusal to discharge the function as director and manager of the corporation, and only for the same term and under the same condition applicable to the nominee. So, ito class yan, ulitin natin ito. So, yung single stockholder, mag-a-assign siya ng nominee and alternate nominee. So, ngayon, kapag siya ay naging incapacitated or siya ay namatay, yan, yung nominee, doon tayo sa incapacity niya. Kung halimbawa, naging incapacitated si single stockholder. So, for the meantime, yung nominee ang magmamanage ng kanyang affairs, okay, ng corporation. Until such time na ma-regain ngayon yung capacity ni single stockholder. So, but in case na namatay si single stockholder, yan, or permanent incapacity ni single stockholder, si nominee shall sit as director, siya yung magmamanage until na yung legal heirs, okay, of the single stockholder have been lawfully determined. And the heirs have designated one of them or have agreed that the estate shall be the single stockholder of the one-person corporation. Okay. Ngayon, si alternate nominee, papasok siya kapag naging incapacitated naman si nominee, yung original yung nominee. So, naging incapacitated, namatay, or nag-refuse to discharge the functions as director and manager of the corporation. Yun. And only for such term and the same conditions applicable to the nominee. So, change of nominee or alternate nominee, the single stockholder may at any time change its nominee and alternate nominee by submitting to the commission the names of the new nominees. Yan. So, records in lieu of meetings, may mga reportorial requirements yan. Sign nyo na lang ito. So, ito. So, liability of a single shareholder. A sole shareholder claiming limited liability has the burden of affirmatively showing that the corporation was adequately financed. Okay? Ito. Conversion from an ordinary corporation to a one-person corporation. When a single stockholder acquires all the stocks of an ordinary corporation, the latter may apply for conversion to one-person corporation. So, halimbawa, ito, originally, regular corporation siya, hindi one-person corporation. Pero yung halimbawa, nangyari, si one-person corporation, si single stockholder, na-acquire niya lahat-lahat ng shares ng corporation na yon, na originally, iba-iba yung may-ari ng shares na yon. So, pwede niya ipa-convert ngayon yung ordinary corporation into a one-person corporation. Yan. So, may mga lang siya, may mga requirements lang siya, submission of documents na required. Yan. The application, if conversion is approved, the commission shall issue a certificate of filing of amended of articles of incorporation reflecting the conversion. So, ito naman, conversion from one-person corporation to ordinary stock corporation. So, a one-person corporation may be converted into an ordinary stock corporation after due notice to the commission of such fact and of the circumstances leading to the conversion. Yan. So, from one-person corporation, maging ordinary corporation, baka pwede niyang in-open niya sa iba, yung sa corporation, nagkaroon ng ibang shareholders, yan, maliban sa kanya. So, yan, nagkaroon din ng conversion. And may mga requirements din dito. Basahin niyo na lang. Ito, in case of death of a single stockholder, yung nominee or alternate nominee shall transfer the shares to the duly designated legal heirs or estate within 7 days from receipt of either an affidavit of heirship or self-adjudication executed by the sole heir or any legal document declaring the legal heirs. Yan. Of this, yan. So, yan. Sign nyo na lang yan. So, the ordinary stock corporation converted from one-person corporation shall succeed the latter and be legally responsible for all the latter as outstanding liabilities as of the date of conversion. So, dissolution, yan. Dito tayo, dissolution. Pasadahan lang natin kaunti. Voluntary dissolution, meron yan, or involuntary dissolution. Okay. Basahin nyo na lang ito, class, itong sa dissolution na part. Okay. Meron din sa foreign corporations. Hindi na natin masyado yan i-discuss. Basta, okay? Just read to the remaining topics ito. So, a corporation, ito kasi dissolution yung totally yung magsa-stop na yung corporation, mawawala na siya. So, basahin nyo na lang siya, itong concept na ito. So, dito tayo nag-end. So, thank you class for this semester. Kahit hindi man natin na-discuss lahat, I hope na meron pa rin kayong natutunan, may nag-retain sa inyo, lalo na dito sa corporation. Hindi natin natapos lahat, but sana may natutunan kayo and I hope that magamit nyo ito. Balikan nyo to when you review for the board exam and also for your qualifying din pala. So, message ko sa inyo class is don't ever give up. I know na may mga trials na dumadating, struggles na dumadating, lalo na sa education and sa inyong pag-aaral. Hindi madali itong online test na ginagawa natin. But, huwag kayong sumuko. Always trust in God, no? Pray to God and give your worries and concerns to God and also work hard, no? Don't settle for yung parang mediocre performance. Lalo na kung gusto niyo maging CPA talaga is kailangan you have to work hard for it, okay? Work hard, extra effort, understand the concepts. Yun. So it will all be fruitful and it will pay you off in the long run. So I hope you all the best. God bless you and dito tayo nag-end. So thank you so much, class.